Hello everyone. In this video, we will try to solve the previous year question paper of Delhi Judicial Service Examination that was conducted in 2011. I was going to solve these questions, so I thought, why should not I include you as well, so that we can discuss it together. The first question says, whoever being legally bound by oath to state the truth or being bound by law to make a declaration upon any subject matter is said to give false evidence when कोई भी व्यक्ति जो बाउंडेड है सच बोलने का शपथ लेके सब्जेक्ट मैटर के रिगार्डिंग सब्जेक्ट मैटर कि कोई भी डिस्प्यूटेड प्रॉपर्टी उसको सब्जेक्ट मैटर कहते हैं। तो उससे रिलेटेड कोई अगर झूठ झूठ कहता है ओथ लेने के बावजूद शपथ लेने के बावजूद, तो फॉल्स वो जो है फॉल्स एविडेंस की कैटेगरी में कब आएगा। ऑप्शन हमारे पास जब वो कोई स्टेटमेंट झूठी स्टेटमेंट बोल दे, या फिर जब उसे पता है कि वो जो बोल रहा है वो स्टेटमेंट झूठी है, उसको लगता है कि वो स्टेटमेंट झूठी है, और या फिर जब उसे पता है कि जो वो कह रहा है वो सच नहीं है। तो इन दिस केस द राइट ऑप्शन इज फोर्थ, दैट इज ऑल ऑफ द अबव। See question number 2. Which section of Indian Penal Code codifies the files of criminal law, the maxim de minimis non curate lex? The right option is option number 3, that is section 95 IPC. Section 95 of IPC. Question number 3. Right of private defense is available. Right of private defense is available. Options that we have: against all members of an unlawful assembly in a free fight, to retrieve from the wrongdoer one's property, or fourth, both 1 and 2 above. The right answer gonna be option first, that is against all members of an unlawful assembly. Question number 4. When an act is abated and a different act is done by the person instigated, the abater is liable for the act done in the same manner and to the same extent as if he had directly abated it, provided that the act done was probable consequence of the abatement, irrespective of being committed under the influence of instigation. Question number 2. The act was done with the aid or in pursuance of the conspiracy which constituted the abatement. Option 3. The abettor had a reasonable ground to believe that a different act may be committed. Option 4, all of the above. The right answer is answer number 2, that is the act was done with the aid or in pursuance of the conspiracy which constituted the abatement. Question number 5. Circumstantial evidence is considered weaker evidence as compared to direct evidence. Question number 5. Circumstantial evidence is considered weaker evidence as compared to direct evidence. Its right answer is first, that is because it has two errors of fallibility: first, of the fact from which inference is drawn being proved, and second, of the inference to be drawn from the fact proved. Question number 6. Whoever causes bodily pain, disease, or infirmity to any person is said to cause hurt. Therefore, it is irrelevant that no force was used. It is irrelevant that no force was used. Let me read this question one more time. Whoever cause bodily pain, disease, or infirmity to any person is said to cause hurt. It is irrelevant that no force was used. Okay. Question number should I read the all options? Shall I have to read all options? First, using force is essential to the offense of hurt. Second, direct physical contact between the accused and the victim is essential to the offense of hurt. It is irrelevant that no force was used. Option for all of the above. Question number 7. Whether a weapon is a deadly weapon is a question of law, fact, opinion to the expert witness, opinion to the judge. I guess fact. Yeah, its right option is second, that is fact. Question number 8. In the law of evidence, fact means and includes anything perceived by the senses. Mm, Anything perceived by the senses, the state of things capable of being perceived by the senses, mental condition of which a person is conscious, or option number 4, that is all of the above. The right option of question number 8 gonna be all of the above. Anything perceived by the senses, state of things capable of being perceived by the senses, mental condition of which a person is conscious. In the law of evidence, fact means and includes. Okay. Question number 9. Only such facts are made relevant by the Evidence Act as are encompassed by Section 5 of Section 55 of Indian Evidence Act, Section 5 of this gonna I don't know. This is a what this is mistake, kind of mistake. Can I check this? Mhm. Let me check. This is not off. This is two. Two. Section 5 to Section 55 of Indian Evidence Act. This talks about relevancy of evidence, the relevancy of facts as an evidence. So the right option gonna be option number one. That is section from Section 5 to Section 55 of Indian Evidence Act. Question number 10. Ram, aged 25 years, tells Sham, who is aged 17 years, and on account of the death of his father, is said that it Sham dies if Sham dies by jumping in a burning pyre of a woman, he, that is Sham, would meet his father in heaven and would find bliss. Sham would be committing suicide, but on account of instigation by Ram, suffered death by jumping in the burning pyre of a woman. Ram is guilty of abetment of the suicide committed by Sham, murder of Sham. No offenses, both a second and above, first and second and first and second. The right answer gonna be option number first. That is abatement for the suicide committed by Sham. Abatement for the suicide committed by Sham. Question number 11. The accused driver of a truck, while driving on the left side, that is his side of the road, sees a cyclist coming from the opposite direction, but on the wrong side of the road, that is in the lane on which the truck was being driven, the road being narrow, and the truck driver, sensing that the cyclist was paddling negligently, maneuvers his truck on the opposite lane, and simultaneously the cyclist suddenly moves to his lane, and as a result the truck overruns the cyclist, causing the death of the cyclist. The truck driver is not guilty of the offense of causing death by rash and negligent act because He did not have the necessary mens rea. He acted bona fide. The truck driver, upon seeing the risk, tried to avoid the risk, was justified in driving the truck on the opposite lane. The right answer is third, that is the truck driver, upon seeing the risk, tried to avoid the risk. The truck driver is not guilty of the offense because the truck driver, upon seeing the risk, tried to avoid the risk. Question number 12. A dying declaration is relevant evidence under section 32 of the Evidence Act, notwithstanding it being hearsay evidence, because notwithstanding it being hearsay evidence, because first option number 1, a statement by a person as to the cause of his death is treated in law as a Solomon statement. Second, if a person is dead and anything said by the person as to the cause of the death is relevant, since the dead person cannot be brought before the court to testify, necessity makes it inevitable to admit said statement. Because it is option number 3, because it is believed that a person would not meet his maker with lies in his mouth. Option number D, because society owes a duty to dead persons to give them justice. The right option for question number 12 is a second. If a person is dead and anything said by the person as to the cause of death is relevant, or since the dead person cannot be brought before the court to testify, necessity makes it inevitable to admit said statement. See question number 13. In a writing containing an acknowledgement by A that he will sell his house in Kolkata to B for sum of rupees 50 lakh or 60 lakh, and having blank space with respect to the particulars of the house, that is the house number, the street number, and the colony not having written, and it not being a dispute that A has a house on a plot of land at measuring 300 square yards, and another house on a plot of land at measuring 1000 square yards at Kolkata. In a suit filed by B against A, B can lead evidence. Options are option number A, to prove that market rate for land in Kolkata is 18,000 per square. Sorry for the interference. Let's continue where we left. We were discussing question number 13. The options were, the first option was to prove that market rate for land in Kolkata is rupees 18,000 per square yards in the colony where his house was situated, to make good the deficiency in the writing by linking the price of 18,000 per square yard as only applicable to the plot at measuring 300 square yards, and the rest being the value of the building. Question number 151. So to prove that market rate for the land in Kolkata is rupees 18,000 per square yards in the colony where is a house was situated, to make good the deficiency in the writing by linking the price of rupees 18,000 per square yard as only applicable to the plot at measuring 300 square yard, and the rest being the value of the building. Option number second, to prove that unintentionally the house number got omitted to be written, and that the writing pertained to the 300 square yards land, and unintentionally the sum of rupees 50 lakh written on the writing got omitted to be scored off. Option number 3, to prove that the property number was left blank because A told him that he would be exchanging his house on the 300 square yards plot of land with another house in a similar colony with his brother, and later on the house number would be filled up. Option number 4, none of the above. Here, the right option is option number 4, that is none of the above. See question number 14. A boy aged about 14 years is suspended in the commission of the offense of murder. He can be made to join investigation. Option number A, at the police station, at his residence, or at any place, or option D, all of the above. The right option is option number second, that is एट हिज रेजिडेंस. सो बच्चे या फिर बूढ़े हों, उनको उनके रेजिडेंस पे ही इन्वेस्टिगेशन के लिए इंटरवीन किया जाता है. क्वेश्चन नंबर 15. A is suspected of commission of an offense of murder, trial whereof can only be conducted before a court of sessions. A appears before the metropolitan magistrate and move an application for recording his statement under section 164 of CRPC and grant of pardon. Who has power to grant pardon? The Court of Sessions. Option number second, the Metropolitan Magistrate. Option number third, that is both one and second above, or option number D, none of the above. The right option is option number second, that is Metropolitan Magistrate. See question number 16. Accused A makes a confession in front of his friend B when B goes to meet A, as A is to be produced for remand in the court. The confession is that he, that is A, has murdered C. The confession is inadmissible in evidence since it is made in police custody. Second option, admissible in evidence as made in the courtroom. Option number 3, admissible in evidence as made before a friend. Or option number 4, inadmissible in evidence as made out of fear. The right option is option number 4. That's first, that is inadmissible in evidence since it is made in police custody. See question number 17. Right of an accused for plea bargaining in India relates to fact bargaining, charge bargaining, sentence bargaining, or all of the above. The right option is option number 3, that is sentence bargaining. See question number 18. X is accused of an offense of rape. He can be subjected to the following test for investigation. First one is polygraph test. Second is narcoanalysis test. Third one is brain electrical activation profile, that is beep test. Or option number 4, that is none of the above. Here the right option is option number 4, that is none of the above. See question number 19. When examined under section 313 CRPC, a circumstance incriminating the accused is not put to the accused for his explanation. The said circumstance cannot be used against the accused because option that we have, it is inadmissible in evidence. Option number second, it because irrelevant, it is because it is irrelevant for the purpose of evidence. Option number 3, law mandates that it cannot be taken into consideration. Option number 4, that is all of the above. Here the right option is option number 3, that is law mandates that it cannot be taken into consideration. See question number 20. After investigation pertaining to an offense of murder, the police files a cancellation report. After investigation pertaining to an offense of murder, the police files a cancellation report. The police files a cancellation report. The report can be accepted only by the magistrate, the court of sessions, the high court, or none of the above. The right option is first, that is by the magistrate. See question number 21. The employer has told the employee in the morning that when the employee leaves the office in the evening to go to his house, he should pick up 50 rupees 50,000 lying in the drawer of the employer and deliver the same to X, to whom the employer owes 50,000. At 12 afternoon, at 12 noon, in the absence of the employer, the employee picks up the money and absconds. The employee is liable to be charged for criminal misappropriation, criminal breach of trust, cheating, theft, or criminal misappropriation. The right option is option number 3, that is theft. Question number 22. B assaults a sharp-edged weapon by sharp-edged weapon, resulting in an injury which is 6 inch long and 1 upon half. If I want to say half centimeter deep in the right forearm of A. B is liable to be charged for a B is liable to be charged for the offense punishable under section 324 of IPC. See question number 23. The magistrate has convinced A for the offense of having cheated a number of investors in the sum of rupees 10 crores. The magistrate is of the opinion that the gravity of the offense warrants a sentence in to undergo imprisonment in excess of 3 years to be imposed. The sentence first excess of 3 years can be imposed by excess of the sentence excess of 3 years can be imposed by the magistrate after putting the accused to notice by the court of session, of whom the magistrate must refer the matter to the court of additional chief metropolitan magistrate or chief metropolitan magistrate to whom the matter is to refer to. Option number D, the by the court of session after notice to the accused. Here the right option is option number 3, that is the court of the additional chief metropolitan magistrate or chief metropolitan magistrate to whom the matter is to refer to. See question number 24. X sends an email to Y from Delhi threatening Y that certain photographs showing Y in a compromising position with a woman shall be posted on the net. If Y does not pay 1 lakh to X, Y accesses the email at his office in Kolkata. The offense can be inquired into or tried by a court at first Delhi or second Kolkata or third anywhere in India, because the email can be accessible anywhere in India. Fourth one, both first and second. Its right option is option number 4, that is both first and second. See question number 25. Nothing is an offense if it is done by a person who is option number first, boy of 6 years having sufficient maturity to understand the nature and consequence of its conduct. Option number second, girl below 12 years having sufficient maturity to understand the nature and consequence on her conduct. Option number 3, a man aged 100 years. Option D, all of the above. The right option is option number first, that is boy of 6 years having sufficient maturity to understand the nature and consequence of his conduct, because कम से कम 7 साल का होना चाहिए, उससे नीचे का कोई भी व्यक्ति है वो उसके द्वारा ऑफेंस किया गया तो वो काउंटेबल नहीं होगा. Question number 26. When the person competent to compound an offense under section 320 CRPC is dead, then the offense cannot be compounded. Second, the offense can be compounded by the prosecutor. Third, legal representative of such person can compound the offense with the consent of the court. Or option number 4, that is none of the above. The right option is option number 3, that is the legal representative. The legal representative of such person can compound the offense with the consent of the court. What was the question? When the person competent to compound an offense under section 320 CRPC is dead, then legal representative of such person can compound the offense with the consent of the court. See question number 27. Under section 209 CRPC, which of the following cases can be committed by the court of sessions by a magistrate if it appears to the magistrate that the offense is triable exclusively by the court of session? Option number 1, a case is instituted on a police report. Option number 2, a case is instituted otherwise than on a police report. Option number 3, both a first and second. And option number 4, that is none of the above. The right answer is option number 3, that is both first and second. See question number 28. A, B, and C plan to enter into a jewelry shop and commit theft at that shop. They collect the implements of the housebreaking and go to the jewelry shop to execute their plan. On reaching there, they find a uh, police patrolling van or station outside. A police patrol van stationed outside the shop and hence return. Their act amounts to option number 1, attempt to commit housebreaking and theft. Option number second, that is criminal conspiracy. Option number three, both first and second, or option number four, that is none of the above. Here the right option is option number second, that is criminal conspiracy. Question number 29. A police officer is directed by the court to arrest B. He arrests C. After reasonable inquiry, believes C to be B. Here the options that we have: A has committed the offense of wrongful confinement as he has arrested C instead of B. Option number second, A has committed the offense of wrongful confinement as he was negligent in arresting C. Also, option number three, A has committed no offense because he arrested C in good faith, believing himself to be bound by law to do so. Option number D, that is none of the above. Here the right option is option number three, that is A has committed no offense because he arrested C in good faith, believing himself to be bound by law to do so. See question number 30. If a series of acts are so connected together as to form the same transaction and more than one offense is committed by the same person, option number A, he shall be tried separately for every such offense. He shall be charged with every such offense and tried at one trial for all the offense. Some of the offenses may be clubbed and tried at one trial. Option number four, that is all of the above. Here the right option is option number option number the fourth will be wrong. The third one is some of the offenses may be clubbed and tried at one trial. This is also not right. The remaining option that we have is option number second, that is he shall be charged with every such offense and tried at one trial for all the offenses. Question number 31. A, going to pilgrimage, entrust 10 gold coins to B for keeping in safe custody till his return. B sells those gold coins to a goldsmith. Here, option number one, B is guilty of theft of gold coins. Option number second, B is guilty of criminal breach of trust. Option number three, both first and second, or option number four, that is none of the above. Here the right option is option number second, that is B is guilty of criminal breach of trust. Question number 32. A committed an offence on October 1st, 2010. On the said date, the prescribed punishment for the offence was 3 years imprisonment. By an amendment on October 1st, 2011, the punishment for the offence was enhanced to 7 years imprisonment. The trial was concluded on October 10, 2011, and A was found guilty. The options that we have: option number A will be sentenced with 3 years imprisonment. Option number second, A will be sentenced with 7 years of imprisonment. Option number three, A will be sentenced for between 3 and 7 years of imprisonment, or option number four, that is any of the above. Yeah, the right option is option number first, that is A will be sentenced with 3 years of imprisonment. uh, can I read this question one more time? That A committed an offence on 1st of October 2010. On the said date, the prescribed punishment of the offence was 3 years. 3 years. Okay, okay. The new rule will be applicable, not would be not applicable as a retrospective. So the right option will be option number one, that is A will be sentenced with the 3 years imprisonment. See question number 33. Error or omission in framing of charges. Option number A is immaterial is material in all circumstances and shall vitiate the trial. Second is material only if it has occasioned prejudice to the accused. Option number three, that is immaterial in all cases. Option number four, entitle the accused to an acquittal. The right option gonna be option number second, that is material only if it is occasioned um, prejudice to the accused. See question number 34. See question number 34. Which of the following charges cannot be compounded without permission of the court before which the prosecution is pending? The right option is option number 4, that is section 388 of IPC. Question number 35. In cases in which a judgment is given that a person as guilty of one of the several offences specified in the judgment, but that it is doubtful of which of the offence he is guilty of, the offender shall be punished for offence carrying the lowest punishment. Option number 3. Question number 36. A indulge involuntary sexual intercourse with B, married woman without the consent of her husband. He is guilty of adultery. The married woman B is liable to be tried with A as an abettor or adulteress or jointly as co-accused, or option number 4, that is none of the above. Here the right option is option number 4, that is none of the above, because because the male person will be liable the to the punishment for the adultery. Question number 37. A person accused of an offence before a criminal court can be called upon to give evidence on oath. The option that we have, option number A, upon a request in writing from the public prosecutor. Option number 2, by an application made by the complaint. Option number 3, by a direction of the court, or option number 4, that is by the accused on his own request in writing. The right option is option number 4, that is by the accused on his own request in writing. Question number 38. Dacoity is robbery committed by 5 or more persons. Question number 39. Police remand of an accused cannot be exceed more than 15 days. Question number 40. Which of the following statement is correct? Option number 1. Section 34 IPC creates a substantive offense. Option number 2. Section 34 IPC introduced the principle of vicarious liability for an offense committed by the co-accused. Option number 3. Section 34 IPC recognizes that the co-participant in a crime must be made liable for his act in the commission of the crime by the co-accused, or option number 4, both second and third above. Here the right option is option number 2, that is section number 34. Section 34 of IPC introduces the principle of vicarious liability for an offense committed by the co-accused. See question number 41. Leading question cannot be asked in examination in chief, or in cross examination, or in a re-examination. The right option gonna be leading question cannot be asked in examination in chief as well as in leading examination. According to me, the right answer gonna be first, that is uh, cannot be asked in examination in chief. I think we can ask leading question in re-examination. Question number 42. The test identification period pertains to the file of the test identification period pertain to the file of investigation or trial, or satisfaction of the investigation officer that he is proceeding in the right direction, or option number 4, that is first or second above. Here the right option is option number first, that is investigation. Test identification period pertains to the file of investigation. Question number 43. Pardon may be tendered to an accomplice under section 306 CRPC when option number A, he is not in a position to stand trial due to the infirm health. Option number 2, when he is declared insane. Option number 3, when he undertakes to make a full and true disclosure of the facts relating to an offense. Option number 3, that is all of the above. The right option gonna be option number 3, that is he undertake to make full and true disclosure of the facts relating to the offense. Question number 44. Criminal justice system in India is based on option number second, that is adversarial trial. Question number 45. Statement of a witness recorded during investigation under section 161 CRPC cannot be used at a criminal trial except trial except to contradict the witness. A statement of a witness recorded during investigation under section 161 of CRPC cannot be used at a criminal trial except to contradict the witness. Question number 46. A rings up the police station and inform the duty officer that he has murdered his wife because he was not preparing food for him. The information is duly recorded by the duty officer. At the trial for having committed the offense of murder, the statement made by A would be option number 1, admissible in evidence, because when the statement was made, when the statement of A was made, he A was not in the custody. A was not in the police custody. Second, admissible only to the extent that A was the informant. Here the right option will be second, that is admissible only to the extent that A was the informant. Question number 47. Under section 200 CRPC, recording of pre-summoning evidence may be dispensed with if the complaint is made in writing by a public servant. Under section 200 of under section 195, under section 200 of CRPC, recording pre-summoning evidence may be dispensed with. Its right option is second, that is the complaint is made in writing by a public servant. Question number 48. Which of the following statement is or are correct? Preparation to commit dacoity is not an offense. Preparation to commit murder is not an offense. इसमें correct बताना है. Which of the following statement is correct? Attempt to commit murder is not an offense, or option 4, that is both first and second above. Its right option is option number second, that is preparation to commit murder is not an offense, because the person is only preparing, he has not executed the plan, and neither he have indulged himself in a part of abatement, any kind of abatement or attempt to murder. Question number 49. Which of the following statements is or are correct? Mens rea is not an essential ingredient of an offence punishable under section 107 of IPC. Second, mens rea is not an essential ingredient of an offence punishable under section 304A of IPC. Option number 3, mens rea is not an essential ingredient of an offence punishable under section 364A of IPC, or option number 4, that is both first and second and above. The right option is option number 4. Option number second, that is mens rea is not an essential ingredient of an offence punishable under section 304A of IPC. 304, as we know, 304A is basically deals with death by negligence. So mens rea is the most important factor in that part. Question number 50. Perjury resulting in the conviction of a person for an offence punishable with death attracts the maximum penalty of imprisonment of life. So this was the last question and with this we have successfully solved the 50 questions of previous year question paper of DJS 2011. We will try to solve, of course I'm going to try to solve the next question in our next video. Till then, have a good time. Bye bye.